Divorce changes everything about your estate plan. Divorce happens. Sometimes marriages don't work out. But if you do happen to get divorced, a lot of times things can get messy. When you have children, that puts another layer of complexity into the situation. Now, I'm not going to spend a lot of time talking about the situation about divorce, good or bad or indifferent. What my goal here is to give you some things to think about for your estate plan when you are divorced and you have children. Now, the idea is you have minor children, but adult children can also be affected. So many people forget right after divorce is to update some key documents, and that can lead to serious consequences. In some cases, an ex-spouse may be named in legal documents and beneficiary designations. What we don't want is for them to accidentally inherit something you didn't want them to, or for them to cause your assets that had beneficiary designations to wind up becoming probate assets. So we're going to talk about some of the unique considerations for divorced families as well. So the first thing you need to do once a divorce is final, oftentimes in the middle of a divorce, there are restrictions on being able to make changes to beneficiaries while the divorce is ongoing. So some pre-divorce planning might be to update some of these documents to change who those people are. Now, let's pretend we didn't have that premonition, so now we are in the middle of this, we've just been divorced. So one of the first things you want to change is if you have a will, make sure you change it. You make sure you change the beneficiaries, the executor. You probably do not want your now ex-spouse to be in any of those documents. Trust, you want to make sure you update those. If your spouse is a successor trustee of your trust, you want to make sure you have addressed that and changed those things. Powers of attorney, beneficiary designations, medical power of attorney. You want to make sure all of those things change so that way you have the right people making decisions that are going to be in your best interest. Texas law may revoke certain provisions benefiting an ex-spouse, but relying on default law can create uncertainty. Laws change in Texas can change every 2 years. So you don't want to rely on what the law could be, especially when you can take action to make sure you decide how things are going to go. So let's get into planning for children. So divorced parents have to consider how the inheritance is going to be managed. If the surviving parent is going to gain control. So if you leave everything to your child, or whatever you leave to your child after divorce, the surviving parent is going to then petition the court to be appointed the guardian, very likely to happen. You may not want your now ex-spouse to be managing your child's now investments. If you have a trust can ensure that those assets are used only for the child's benefit. And you can create a third-party trustee or a different trustee than your ex-spouse to serve as the trustee for the benefit of your child. So those are things that are really important to see who's going to be managing the assets of the child, who's going to be running the show for that child. You want to make sure you've got that taken care of. Now, with divorce comes remarriage. So sometimes we can have blended families. Now, blended families can include stepchildren, half-siblings, and new spouses. So the estate plans need to clearly address how those relationships work. So let's kind of break down what each of those things mean. Stepchildren are children of the two spouses that are not actually blood siblings. They are the children of one of the two parents. Half-siblings are children of one of the parents, but they have a different other parent. They have a different father or a different mother than each other. So those would be half siblings. Now, new spouses, that's pretty self-explanatory. It's who's the new spouse after the divorce. There are some situations where things are very harmonious, things work very neatly, and there's other times when they don't work so neatly. But it's important to make sure you're very clear, especially when things can be messy, very clear as to how each person potentially is going to inherit from the estate or through the trust. Trust, especially in blended families, are very, very helpful because they provide all of the instruction as to how everything is going to be distributed without having court involvement, without having to increase the opportunities for somebody to hire a troublemaker attorney and put a wrench into the workings. With the trust, there isn't any court that needs to supervise anything, so everything has to happen based on the document. Now, one of the key takeaways I hope you take from today's podcast is that after divorce, an estate plan should be thoroughly and carefully reviewed and updated to reflect the new family structure. If there is a remarriage after divorce, another very important time to go ahead and update those things. Now, if you haven't done any kind of planning up to now, and now you find yourself divorced with children, now is a very, very important time to go ahead and make that plan. Don't hesitate. These are things that are extremely necessary for your protection, for your wishes to be followed, and to make sure that your kids are properly taken care of and that they get the care that they need if you happen to pass away. So if you've liked what you've heard today and if you liked what you've been hearing in our podcast, please follow, and that way you'll have the updates on future episodes. You'll be notified. And if you'd like to learn more about protecting your assets and taking a deeper dive on estate planning, we have a webinar called Bulletproof Your Legacy. This, we go into a little deeper dive into the different ways to plan your estate. So we'll put that in the show notes, and there'll be a link down there so that you can go ahead and access that. Until next time, we look forward to seeing you again.